Welcome everyone to the College of Labor and Employment Lawyers and the Metropolitan Washington Employment Lawyers Association's fall webinar, Civility from the Podium, Professionalism as a Strategic Tool in Employment Appeals. I'm Scott Oswald, a fellow of the college and MWELA's Bench Bar Committee Chair, and I'm your moderator for today's program. I'll take questions throughout the program. Just use the Q&A feature at the bottom of your Zoom screen. We'll try to get to as many of those as we can at the end. Before we begin, we have opening remarks from Fred Suggs.
On behalf of the College of Labor and Employment Lawyers, thank you for attending today's virtual program on Civility from the Podium. The college prides itself on promoting professionalism and civility among the labor and employment bar. This program is particularly important given the Fourth Circuit's traditions of civility and professionalism. Scott Oswald has spent countless hours planning and coordinating the program. We'll all benefit from the panel's view of professionalism in our circuit. Mikhail Shinar will introduce our distinguished panel.
Thank you, Fred. I'm Michal Shinar. I'm a senior counsel at Joseph Greenwalls and Lake in Greenbelt, Maryland. And I'm really honored to introduce this event today with our panel of very distinguished judges. I serve on the board of the Metropolitan Washington Employment Lawyers Association, which is one of the sponsors of today's event. And like the College of Labor and Employment Lawyers, values the issues of professionalism very deeply. We're an organization of nearly 400 lawyers in the Maryland, DC, and Virginia area who represent employees in all types of employment matters. And we also regularly hold educational programs on issues relating to employment law, professionalism, and legal ethics. We are proud to hear from our two judges today on the Fourth Circuit Court of Appeals. Our work is so heavily shaped by the decisions that they and their colleagues issue, and we're grateful that they took the time out of their busy dockets to speak with us today, employment lawyers on all sides of the aisles, about this important topic of professionalism as a strategic tool in employment appeals. First, we have Judge Albert Diaz. Judge Diaz, as an alum of the University of Pennsylvania, holds a Juris Doctor from NYU Law School in New York, as well as a master's in business administration from Boston University. He's a former lieutenant in the Marines, where he served as a prosecutor, defense counsel, and appellant government counsel. He then served in private practice while remaining in the Marine Reserves, continuing his legal work. From 2001 to 2009, he served as a North Carolina Superior Court judge, and then President Obama nominated him to the Fourth Circuit in 2009 and was confirmed in 2010. Next, we have Judge Stephanie Thacker, who is an alumni of Marshall University, as well as holds her JD from West Virginia University School of Law, Order of the Coif. She served as a federal prosecutor for 12 years, both in the United States Attorney's Office for the Southern District of West Virginia and at the Department of Justice in the Child Exploitation and Obscenity section. Judge Thacker then went into private practice, and then in September 2011, President Obama nominated her to the Fourth Circuit, and she was confirmed in April 2012. Judge Diaz, Judge Thacker, thank you both for being with us here today. And with no further ado, I will turn the platform over to Scott Oswald to begin our discussion.
Mikhail, thank you. And Judge Diaz and Judge Thacker, thank you for being here. We are grateful. Let's dive right in and talk about practicing with professionalism and civility before the Fourth Circuit. Judge Diaz, is practicing with civility and professionalism important to you?
Thank you, Scott, for that question, and thank you to the College of Labor and Employment Lawyers and the Metropolitan Washington Employment Lawyers Association for having me and my dear colleague, Judge Thacker, here this, I guess it's this afternoon. We are pleased to be here and pleased to talk about this, this important topic. The short answer is yes. You know, professionalism and civility is something that is baked into our DNA on the court. And I know sometimes lawyers hear that from judges and wonder exactly what that means, but it really is part of the culture and tradition of the Fourth Circuit. We're a medium-sized court. We've got 15 active judges, and the number of senior judges is continuing to increase over recent days, but 4 or 5, I think, And we know each other personally. We care deeply about each other. We're friends. And we care deeply about the ethos and the work that we do as a court in trying to get to a fair and just resolution of the often very difficult and nuanced cases that come before us. And we can only do that if we can rely on the professionalism, civility, and integrity of the lawyers who come before us. We have a tradition on our court that sadly has been foregone now because of the pandemic for the last year and a half, almost 2 years. And that is after each argument, we typically come down from the bench and greet the advocates individually after each argument and then go back on the bench. For lawyers who aren't familiar with that practice, some who come from out of the circuit, as they see the judges come down from the bench, they may be wondering whether or not we're coming down to finish the job, but that's not the case. We come down because in admiration and in respect for the work of the lawyers, which is every bit as important, if not more so, than the work that we do. Collectively, we are engaged in an enterprise to try to find justice. And we recognize that lawyers have a duty to their clients. They have an obligation to be aggressive and effective advocates for their clients, but that does not mean that they can't be professional and civil when they go about that very important work. In fact, those two go hand in hand, and you're going at cross purposes if you're engaged in the kind of incivility and stubbornness and downright meanness that sometimes is the bane of our existence as a profession. Thankfully, that's a distinct minority of lawyers. My experience has been that the vast majority of lawyers in the profession work hard, honorably, and honestly to try to do the right thing in each and every case that they're engaged in. And we expect that from the counsel who come before us.
Judge Thacker?
First, I want to echo Judge Diaz's thanks for having us both here today to talk about this important topic of civility and professionalism. I think it's even more important now to discuss that we're all, at least for the last couple of years, sort of distanced from each other, doing a lot of things like this on the screen and a lot of hearings apart from one another. Sometimes I think that can make it easier to forget the importance of civility and professionalism. In the Fourth Circuit, though, as Judge Diaz said, we do have a history and tradition of being a collegial court. It's our reputation that we are one of, if not the most collegial courts in the country. And the way that lawyers see that typically is what Judge Diaz described is when we come down from the bench and greet counsel. I saw it and continue to see it even more readily once I crossed over to the other side of the bench. Our court really, as Judge Diaz said, we really do like each other and are friends and strive. We have a number of ways we strive to continue to foster that in our court. I mean, I even know Judge Diaz's dog's name, is a puppy. I sent her a little puppy gifts when she arrived. So little things like that. I mean, there's only 15 of us. You know, it's a very small law firm, and it's a lifetime appointment. So we're married pretty much, professionally married at least for life. And so we really do strive on the court to maintain that professionalism, and we expect that the lawyers that appear before us do as well. And you'll see, for example, if it does happen sometimes that a lawyer arguing in front of a panel disrespects a particular judge in some way or interrupts them, very likely another judge on that panel will interject to sort of cut that off. So That's one of the ways that we focus on civility. And in our court, we all 15 go to Richmond when we do go to Richmond, and hopefully we'll be back soon. We all go there together for the week, so we see each other. We rotate panels every day, which I think is a good thing for a number of reasons. You know, it helps to not foster groupthink, and also you may be on a panel with one person that you agree with one day, and the next day maybe you disagree with them. But mixing it up sort of helps to remember that you're going to see that person again. Just like as lawyers, you should remember in the courtrooms, particularly in employment law, which is a unique area of the law, you're very likely going to run into each other again. So it's good to maintain civility and good relationships. I know that for sure in West Virginia, having practiced here, that you see the same people over and over again, and for sure your reputation precedes you.
Judge
So,
Thacker, thank you.
yes.
Let's talk about civility and professionalism in brief writing. Judge Diaz, talk to us a little bit about how that makes its way into the briefs that are filed before the court, and how it should make its way into briefs filed before the court.
You know, on our court, I'll take a step back and explain the importance of a brief. A brief is obviously important in every appeal, but even more so, I think, on our court. We have one of the lowest argument grant rates in the country. We hover somewhere around 9 to 10% of the cases that actually get argued. So the brief is, in the vast majority of cases, including probably the vast majority of employment appeals, is going to be your one and only opportunity to try to persuade us. And anything that detracts or distracts from that, frankly, is not helpful. And so, and for me personally, anyway, one of the pet peeves that helps to detract or distract from my ability to focus on the issues, the very important issues that the parties want to bring before me, are personal attacks and you know, histrionics and over the top language in briefs that really where lawyers simply just get in the mud and don't focus on the things that are important, the substantive issues that are important. You know, it's fine, I think, obviously, to point out a mistake, and the hope and expectation is that the mistake by the other side will have been an honest one, and that's perfectly appropriate. It's not appropriate, I think, to characterize that as something more sinister. Even if you believe that to be true, and even if the record seems to suggest that, leave it to the judges to decide what, if anything, to conclude about something in a brief that you disagree with. Just point out the mistake, whether it be a factual one or a legal one, a misstatement as to the holding in a case, and tell us that a mistake has been made, and here is exactly what the case holds, or here is what the record shows. We appreciate that, because obviously it's important for us to know and understand that, and we'll frankly probably figure it out on our own, but it's a lot easier when the lawyers help us to that aim. But I personally don't appreciate the additional step of somehow of engaging in a fist fight, a verbal fist fight with a lawyer on the other side. So it's really important to focus on what's important, and what's important is the objective, and the objective is to persuade us that your view of the case is correct. And anything that distracts from that, you need to strike it from your brief, you need to strike it from your psyche, and again, focus on those things that are important.
Cases come and go, reputations will forever be etched in judges' minds. Judge Diaz, do you agree with that?
Absolutely. You know, as Judge Thacker mentioned, we're friends, we talk, we cackle, and sometimes, and more often than not, what we talk about are lawyers that we can trust, and that small group of lawyers that we can't trust. If you're in that group of counsel that when you're asked a question about the time of day or the weather, and you give an answer, and the lawyer and the judges have to take a recess to confirm that by stepping outside and looking at a clock or checking the weather outside, that's not a good look for you, and doesn't bode well for your ability to persuade us in court. You know, it's not all of us can rise to the heights of, you know, the giants of appellate advocacy and practitioners, the John Roberts of the world, the Thurgood Marshalls of the world. You know, there's a select group of those, but there's no reason why you can't be the most honest lawyer, or for that matter, the most honest person that walks into any room. That doesn't take any great ability. It just takes the determination that you will not compromise your integrity for any cause, any client, any reason. And those are the kind of skills that hopefully lawyers learn early on in life, maybe as early as kindergarten, I would hope. But if you haven't figured that out, it's never too late to figure it out, that, as you point out, your reputation precedes you in everything that you do.
Judge Thacker, one of the things that is important to you is joint appendix sites in the briefs that are filed before you. Tell us a little bit about that.
So joint appendix sites in the briefs is one of the first ways a litigant can establish their credibility or not. Going through the briefs, if there are some serious statements or some important statements that are made and there is no JA site, that's a signal, at least for me and other judges on the court. I mean, if the whole argument is about whether the car is blue, and in your brief you say clearly the car was red and there's no cite to the JA, number one, that tells me either that's a sloppy brief because there's no cite to the JA, or worse yet, it sends me looking through the JA, and more often than not, there's no cite to the JA because the car wasn't red or blue or whatever you're trying to say it is. There's no cite because that's not accurate. And I don't think that people are trying to be disingenuous all the time without the JA sites, but it doesn't help your case, because first of all, we have to go rummaging through the record to find the site, and the record is everything in our business. Second of all, it signals that perhaps that's a weak point in your case. And third of all, it's just sort of sloppy brief writing that is maybe a subliminal hit on your credibility with the court. But more often than not, if there's not a JA site for something big like that in the record, then it's not in the record. I learned early on, it freaks my law clerks out when we very frequently from the bench ask, well, where is that in the record? And oftentimes I'm asking it because I know it's not in the record. I've already looked, or the opposite is in the record. But my law clerks are, I found out later, over there sitting at their little law clerk desk, freaked out because they think they've missed something, but that they have not. So JA sites are a particular pet peeve of mine. And I'm not saying you have to put a JA site after every sentence you write, but certainly after big chunks of factual statements or key factual statements, a JA site is important.
Judge Diaz, why is engaging with the standard of review so important to you?
Thank you for that question. We live and die and breathe standards of review here as on the circuit. That's just the reality of the work that we do. When I was a trial judge, obviously I didn't have to worry so much about that other than the standard of harmless error, which I was grateful for, because we all recognize that trials are far from perfect, and so are hearings. But the reality is that it's precisely because we have standards of review that lawyers need to pay careful attention to them. It does you no good to run away from a standard of review if one is not favorable to you, because that's sort of how we're going to gauge. In fact, that is how we're going to gauge the merits of your appeal. And so you're running away from it simply detracts from your ability to be an effective advocate. If it's a de novo standard of review, that's great for you if you're the appellant. If it's abuse of discretion or plain error, whatever the standard is, engage with it and be honest about it. It just, we're gonna focus on it. So it's important for you to be if you're going to be an effective advocate on our court, any court for that matter, you need to focus on that as well.
Judge Diaz, the power of story, you're reading literally thousands of briefs per year. Why is the story important for you?
Well, we're all human, right? And we all like a good story. And sometimes that's easy to do in an appeal. Sometimes it's a little bit harder. I think employment law appeals lend themselves to often heart-wrenching and emotional stories. And it's not to say that we get caught up in the emotions of the case, because obviously we can't do that. We have to focus on the cold, hard facts. But as you point out, Scott, the fact is that we're inundated with paper. And it's a lot easier, I think, for a judge to focus and pay attention to a brief that tells a compelling story, an accurate one, obviously, but a compelling story, and a brief that eliminates anything that is not important or relevant, that doesn't move the ball in terms of telling that story, precisely because of the volume of the work that we have. The better a lawyer is at being concise and yet complete, the more effective that lawyer is going to be in front of the panel. And that's hard. I mean, it's easy to write a 50-page stream of conscious, 60, 70 pages, and then say, I'm done, that's it. Anybody can do that. It's a lot harder to try to condense that into something a little bit more manageable that tells that story completely, but concisely. But you have to be a ruthless editor. Part of being a professional is being cognizant of the fact that you have to be willing to strike things that you might be in love with, but simply don't move the ball in a piece of writing. You have to be willing to let others engage with your writing and be critical and take that criticism constructively. And because I think collectively the work is much better. It certainly is when it comes to opinion writing in chambers. My name goes on the opinion, but it's a collective enterprise often, and it's a much better work product because of it. So, tell a compelling story, do so concisely, completely, eliminate everything that does not move the ball, eliminate sort of talking phrases, dates, acronyms, abbreviations. Lawyers tend to, in law school, to learn to use 10 words when 2 or 3 will do. Don't do that. Pick up a piece of newspaper writing, if New York Times, Wall Street Journal, whatever it is that is your cup of tea, and take a look how journalists write. Now, you're not writing a newspaper article, but the sort of the punchy, direct, concise form of writing that appears in those kinds of materials, I think is a good sort of example of how you can be an effective writer in a brief.
Judge Thacker, what's your favorite part of the appellate brief?
My favorite part of the appellate brief is the summary of argument. As has been noted, we read a lot. I've calculated, hundreds of pages a day that each of us read. And so for me, the summary of argument is a useful tool, and it's the first thing I read. It does 3 things, or should do 3 things for me. And so lawyers shouldn't sort of overlook it. But along the lines of telling a compelling story, as Judge Diaz said, the summary of argument should tell us what the case is about, why we should be particularly interested in your point of view, what it is you want us to do, and how you want us to do it, how you want us to get there. The summary of argument for me should have three focuses: a factual focus, a legal focus, and a decisional focus. So it sort of briefly tells the story, tells us what you want, and tells us how you want us to get there. And then one more point just on the briefs in terms of telling the story. Remember, when you're telling it to us, since we are not the district court, we don't already know everything from years of litigation. So don't start in the middle of the case as though we know everything. We don't, and we never will. So start at the beginning, tell the compelling story, tell us what you want, tell us briefly, and tell us how to give you what you want. Sort of the same thing as you would do in oral argument.
So Judge Diaz, the statement of facts, is it a good place to try to hook a judge?
Well, I think every part of the brief is important, and I agree with Judge Thacker that the summary is really important, particularly for a busy judge. And I want to make it clear, and I think Judge Thacker would agree that we read everything, but we because of time constraints, if we go back to something, it's likely we're going to go back to the summary of the argument if we need to reorient ourselves to the brief. But yeah, the statement of facts is critically important. Although, obviously the facts are what they are, and the record is what it is. You can't change the record. It's either, as Judge Thacker said, in the record or not. But that certainly is a great place to begin to tell that story of why it is that your client has been wronged if you're the appellant, or why your client, the result for your client was a correct one if you're the appellee. And it's not a question of spinning. I don't like to use the word spinning the facts, because that suggests that a certain sleight of hand when it comes to the record evidence. The record evidence is what it is, and it doesn't change. But it is important to sort of highlight exactly what that record is, for the very reason that Judge Thacker mentioned, is oftentimes we're inundated with this huge volume of paper. We have the JA, obviously, which is a summary of the record. But even that can sometimes be voluminous, because the lawyers tend to be over-inclusive rather than under-inclusive. And so the statement of facts is a critical sort of funnel that focuses the court's attention. And if it's done accurately and correctly and with a certain amount of flair, then sure, it'll grab at least my attention and keep me focused on the case. And so, yeah, I think it's a critical part of the brief.
The relief section, do lawyers always tell the court what they want the court to do?
Unfortunately not, as Judge Thacker mentioned, and sometimes it's not intuitive. Sometimes it's easy to figure out exactly what it is that the relief that's being sought, but oftentimes it's a little bit more nuanced. And frankly, sometimes we're forced to guess because we not sure. So clearly, I mean, if you're taking an appeal or you're defending an appeal, it's with a purpose, right? And the purpose is that bottom line. What is it you want the court to do? Vacate, reverse, outright, affirm in part, whatever it is. As Judge Thacker mentioned, it's really important to be upfront about that. And we might disagree with you, but at least we'll understand where you are, and won't have to try to assume things or try to figure it out. And make perhaps an incorrect assumption about what the relief should be.
What are the one or two things, the mistakes you see over and over in opening briefs that are filed with you that you're reading?
I wouldn't put this in the category of mistakes. I think I've focused on this already. It's just that briefs just tend to be a little bit too long to suit me. And length is, obviously in each case is different. Sometimes there's just no getting around the fact that it's going to take a few pages to get to where you want to be, given the nature of the appeal, and that's okay. But I think the assumption on the part of lawyers is that we need to get it all in because we just need to do it. It's just ingrained in our psyche that it's better to be over-inclusive than under-inclusive, and that's just not right. That's wrong. Just like a trial lawyer should understand that a jury collectively typically will get to the right result and doesn't need to be repetitively spoon-fed each and every piece of evidence over and over and over again. The same holds true for an appellate brief. And an opening brief, the opening brief obviously is the brief of the appellant. The appellant is lost below. And so you need to make a compelling case as to why it is that the trial court or the jury, if it was a jury trial, got it wrong. And that's, that's a hard sell because by and large, when appeals come up to the court, they're for the most part affirmed. And that's part of the process that I talked about earlier. And that is that we have these standards in place that will ensure not that a perfect trial occurred, but that one free from error that mattered occurred. And if you can't show that, if you can't show that a mistake was made that mattered, then your opening brief is not going to be an effective piece of advocacy.
Let's turn to the responsive brief. Judge Thacker, what's the most underutilized section of the responsive brief?
I'm not the most underutilized section of the responsive brief. I don't know so much. I could pick anything out in particular in the responsive brief so much as the reply brief. And for me, I'm always surprised when a reply brief is not filed. I cannot understand why somebody would not want the last word. I certainly always want the last word. And when there's not a reply brief filed, it makes me think that you have no response, you have no comeback perhaps to what the responsive brief has said. And I always make my law clerks, I don't make them do anything. I always ask my law clerks to go back and make sure that there wasn't a reply brief filed. I also wanted to go back, if you don't mind, Scott, to the opening brief. One of the things that I see as a challenge in opening briefs is how often the advocate does not front their issues in the opening brief the way I know all of you all would in court. If you had a witness on direct exam, what do? You front the issues on direct exam. You don't want it to come out on cross. And so I'm always surprised at opening briefs that don't front the issues. They have me hook, line, and sinker in their summary of argument that, and in their compelling statement of the facts, I can't believe this happened to this person. This is horrible. I'm just ready to reverse right now. And then I read the response and it's not quite as it seemed. And that then is another way to lose credibility in the opening brief and maybe never get it back, whether you file a reply or not.
Judge Thacker, just conceding a point, is that an effective way to gain credibility with the court?
Yes, thank you, Scott, for mentioning that. I had just written that down in my notes earlier. Conceding a point is certainly an effective way to gain credibility with the court, in the same way that sort of struggling and fighting against a point that you obviously should concede and move on and then tell us why maybe that point is not as important as we think it is struggling against it is also a way to lose credibility with the court. Your opponent, appellant or appellee, cannot be wrong about everything. So conceding a point is just as effective in the brief as it is in court, at trial, and oral argument.
How about the use of humor? Is humor ever unwelcome in a brief, Judge Thacker?
I don't really enjoy humor in a brief. I enjoy humor, just not particularly in a brief, and frequently not in oral argument either, unless of course one of my colleagues is making a very funny, hysterical joke. But the litigants, it's serious business. And I'm, thinking of it also from the perspective of having been a litigator as well before I got this job. I'm not sure clients whose livelihoods are at stake and who take it as seriously, as they should, would appreciate humor over their case either. But that's just me.
Judge Diaz, responsive briefs that aren't actually responsive. Do you ever see that?
It's kind of a loaded question. Yes, and they're frankly not effective. So the whole point, obviously, of a response brief is to deal directly with the issues that have been brought up in the opening brief. And I want to follow up. Judge Thacker made a good point about the issues in an opening brief. And part of the point that I was making about conciseness is, as Judge Thacker mentioned, there are going to be issues that occur throughout a trial, but not every one of them can and should matter. And so the effective advocate is the one that can winnow the issues down to those 2, 3, or 4 issues that really mattered in a trial and bring those to the attention of the court in its opening brief. A responsive brief has to deal with those issues and can't sort of interject or shouldn't interject issues that really don't matter, but deal directly with the issues that have been raised by the appellant in its brief. And as Judge Thacker said, it can't be that both sides are right on every point. And a concession in a response brief, one that is born of preparation and an understanding that that concession doesn't matter, is a good thing. Now, sometimes you can't concede, right? There's some things that you can't concede on, and that's okay. I think that judges will understand that so long as you've got a viable point to make on a disputed issue of law or fact, then that's what advocates do. They make the argument and they let the court decide. When you've got some things that are pretty black and white, and you're being persistent and stubborn and not conceding something that is clear as the nose on your face, that becomes problematic, and that detracts from the professionalism of the lawyer and detracts from that lawyer's credibility and reputation.
Your bench memos, Judge Diaz, tell us about your bench memo. What is it and how do you use it?
So, it's interesting. I sat on the Ninth Circuit by designation some years ago, and Judge Thacker has done this too. And it's interesting how different courts utilize their law clerks differently. So on our court, I don't know this for sure, but I think virtually every judge has a law clerk prepare a bench memo in every case. I know I do for each and every case. And that, frankly, is the first thing that I read before I dive into the briefs and the record, because it sort of sets gives me a sort of a foundation and background for what is to come. And so I rely on bench memos quite heavily on the front end to get me oriented. And I want to be clear that I read everything else. I read the briefs, obviously, in the portions of the record and JA that are relevant to the appeal. But that bench memo is really the first thing that I look at. And I ask my law clerks to give me a specific recommendation as to the disposition of the case. Now, oftentimes we'll agree, sometimes we won't. And when I go back after reviewing the entire record, I'll go back with my law clerk, particularly if I disagree, and we'll sit down and talk about those areas of disagreement so that I understand exactly where he or she is coming from. And I want to point out why I think the case should be decided differently. So bench memos are an important part of the process, one that is obviously not, the lawyers are not privy to, but I think it's important to understand as a lawyer that your brief is probably going to be read the very first time by a young law clerk who may be right out of law school and be putting pen to paper and preparing a bench memo. That could be good, that could be bad, but that's the reality of the work that we engage in. And so, that's an important part of the process.
Judge Thacker, tell us about the structure of your bench memo.
I appreciate this question because, like, different courts do things differently. Different judges, even on the same court, do things somewhat differently. And in the Fourth Circuit, or you may know, for the most part, generally the judges, we don't talk to each other about the cases or our bench memos or any of that before we hit the bench. So, so it's interesting to hear how Judge Diaz approaches his bench memos. I have, you know, a set format for bench memos. I have a lot of set formats and processes in my office. My bench memos look a lot like maybe something, you know, the memos you would write in law school, and they may be, I think, more fulsome than some other bench memos because they're designed to be more readily converted into at least a first draft of an opinion if we get the opinion. But for me, I actually, I have a rule where I don't want the law clerks to talk to me about, they can talk to me, just not about the case or the briefs or the bench memo while they're working on it. Because at the same time they're working on the reading the briefs and writing the bench memo, I'm reading the briefs and sort of formulating my own opinions that I want to formulate separate and apart from them or what they may think. And I learned early on, I can't even look in a law clerk's direction when they might be talking about a case, because if I raise my eyebrows like this, they think I think they must be completely wrong. It's not everything is about, you know, not everything's about them, but we do the bench memos and brief readings separately so that when we come to the same conclusion, hopefully, when I get their bench memos, and we don't always, and that's fine, then it's validation. Then at least one other person has agreed with me. And then on our court, it can be even more validating that none of the judges have talked to each other before we go out to hear oral argument. And yet, more often than not, the three judges on a panel will agree. So now you've had three people and at least three law clerks who have done a bench memo that all agree on what the resolution should be on a case. So it's sort of validating in that way.
Judge Thacker, talk to us about maybe some tips on compiling the record, the joint appendix.
So for compiling the joint appendix, don't just go, okay, here's the record. This is now the JA, and put everything into the joint appendix. That's, of course, way too much. I would have employment cases, I'm sure, have pretty extensive records and would definitely be way too much. You don't want to ask a law clerk or a judge to be rooting through thousands of pages of record trying to find what it is that's important about your case. But at the same time, don't leave out, you know, the most relevant stuff. So there's got to be some happy medium between throwing everything in and, you know, not putting enough in. And certainly, obviously, you want to consult with opposing counsel to make sure that what's important to them is also in there. Sometimes it happens that supplemental joint appendices have to be filed because either someone left something out that the other side wanted in, or frankly, you know, sometimes you're following up after you filed your brief or preparing your case and you realize that something needs to be supplemented in the JA. Don't hesitate to make a motion to supplement it if, you know, if it's necessary.
And you're okay with that? I mean, if the parties say, "Ooh, we need to include one more thing," generally, you're okay with filing a supplemental appendix?
Well, I mean, we're definitely okay with filing a motion and trying to seek to supplement the record if it's necessary. And yeah, frequently, if it's a relevant document, if it is a relevant document to the parties, then likely it will be a relevant document to the court. And we would want it to be in the record too. Not all motions to supplement the joint appendix prevail, but it's certainly not something you should be hesitant to do if you think it's necessary. But I would say that a motion to file a supplemental joint appendix that has thousands and thousands of supplemental pages probably going to fail.
Let's turn to oral argument. Judge Diaz, how does an appeal filed with the court end up on the oral argument docket?
So we have kind of a funnel approach when it comes to putting cases on the oral argument calendar. And I mentioned early on in the presentation that we have one of the lower argument grant rates in the country. And some people are okay with that. Some people perhaps not so much. I personally think that we could probably stand to hear a few more cases at argument, but I do agree that it's obviously impractical to get every case on the calendar, even if we wanted to, but there is some importance to having a public proceeding with lawyers appearing and the cases being heard, at least those cases that warrant argument. So it begins to answer your question directly, it begins in the clerk's office. The clerk's office takes an initial pass through cases that are on the docket for potential oral argument cases. And all of these are tentatively placed on a calendar, but first by the clerk's office. And we have a separate Office of Staff Counsel that screens cases and makes some additional determinations as to whether or not a case should be on the calendar. And ultimately, the responsibility and authority for cases being on the calendar devolves to the judges, who can either add or remove cases from the calendar as appropriate. And so that's sort of the mechanical way by which the cases get on the calendar. In terms of what it is that the folks who are in this chain of work are looking for, it's sort of the usual suspects. If you've got issues that appear to be the subject of a circuit split, issues of constitutional significance, close questions, whether factually or legally, oftentimes get on a calendar, so things like that are the kinds of things that we're looking at. And cases come on, they come off throughout the time as we're looking at the calendar. And so by the time cases get on our calendar, it's because there is, by definition, there's at least one issue that simply doesn't lend itself to an easy disposition. And so we think it important to hear from the lawyers about it.
Judge Thacker, oral argument. Does oral argument make a difference?
So as a lawyer, at least when I was practicing as a lawyer, I know oftentimes it may seem like, or litigants may think going into an argument or a hearing, that the judges have already made up their minds. And certainly we go into oral argument leaning one way or the other. We, as Judge Diaz said, we've read everything. We've got our bench memos. We've gotten recommendations from our law clerks. So we do have thoughts and opinions going, not opinions as in written opinions, but an opinion as to how the case should come out going into oral argument. But frequently on our court, it's been my experience that at least on several occasions during court week, I or one of my colleagues does change their mind after oral argument, or our thoughts are solidified as a result of oral argument. Frequently, I will let my law clerks know after the bench memo, as Judge Diaz does as well, I think, whether or not I agree with them. And sometimes I will say, I'm 51-49 on this case, because as Judge Diaz pointed out, not all of our cases get oral argument. So only sort of the most challenging ones get oral argument. So it's often not readily apparent what the resolution should be. So oral argument is a very important tool to get questions answered. And also for me to hear from my two colleagues for the first time, since we have generally not discussed the case. And frequently the two other judges on the panel bring much more insight to the case than I had going into it. So it's oral argument makes a difference for me. And like Judge Diaz, I'd be willing to do it more often. I love oral argument.
Judge Thacker, what are the two things that appellate counsel should address in the first 2 minutes of every that opening argument, that first opportunity?
Well, I guess I will say for the opening few minutes of oral argument, I'll do a do and a don't in the first few minutes. The do for me is like the summary of argument in a brief, the roadmap with 2 to 3 important points in your case and how you want us to resolve it and why. Again, the sort of decisional focus and legal focus. It's particularly important, I think, in front of the Fourth Circuit to have a roadmap of 2 to 3 things you're going to say up front, because for us, it may be the last thing you get to say that you have written down on your paper and planned, because we're pretty generally a pretty inquisitive bunch, and we'll start asking questions. So the roadmap is helpful to direct us and also helpful for you to get the points out that you would like to make and to let us know what you want. So that's the do in the first couple minutes. The don't for me in the first few minutes of oral argument is don't spend your time with a long, detailed recitation of the facts, because we have read everything and we do know the facts. So for us, I think it's more important to apply the analysis and the law to the facts. I had one argument where the lawyer spent like 18 minutes talking about the facts, 18 of the 20 minutes that the lawyer had. And I said earlier that, you know, we're a pretty inquisitive bunch, but it was just such a long, monotone recitation of the facts that I don't think anything could snap us out of it. So 2 minutes to talk about what that lawyer wanted. So a recitation of the facts isn't helpful.
Judge Thacker, what are some of the ways that lawyers can manifest professionalism and civility from the podium?
From the podium, did you say?
Yes.
Well, first of all, I always go back to something a state court judge told me that a state court judge years before had told him, and it's the 4 B's of advocacy, I guess. The first one is be on time. Believe it or not, I have had occasion where the lawyer isn't there on time for argument. They've stepped out and we're all sitting there on the bench waiting. That's probably not a good way to start. The second one is be appropriately dressed. And for me, that just means nothing distracting from what you're saying. You want us to be focused on what you're saying rather than what's you know, the bright red loafers you might have on or something like that. So be appropriately dressed. The third one is be prepared, and the fourth one is be brief. Just because you have 20 minutes doesn't mean you have to use 20 minutes. And the cue there is if we are all 3 just staring intently at you for the last 10 minutes of your argument and we don't have questions, it's probably an indicator that you don't need to take up the whole 20 minutes. If all the questions have gone sort of against your opposing counsel and it's sounding good for you, you probably don't need to take up the 20 minutes. And then certainly if your red light comes on, depending on what the presiding judge says. You can do the fourth B, which is be brief. The most distracting thing at oral argument, though, is lawyers who just won't answer the question and won't answer the question that is asked, and or get sort of testy and fight with the judge that's asking the question. You'll never get turned loose if you don't just answer the question that is asked, so that then you can move on.
So let's talk about the conference that occurs after oral argument. We mentioned the fact that judges don't meet before the oral argument, but they do meet afterward. Judge Diaz, tell us a little about what happens afterward. Just peel back the curtain for us.
Well, like most things, it varies depending on the panel. When I first came on the court, generally our conferences were fairly brief. I think over the last couple of years, my observation has been that the conferences have gotten a bit longer and more engaged. And sometimes, it's the nature of the beast is that there's not much that needs to be said about a particular case, and that's perfectly fine. But in practical terms, what happens is we typically have 4 cases that are argued by each panel, and the panel members go down the list of each of the 4 cases and solicit the views of the panel members on each of those cases. And a discussion may then ensue with respect to one or more of those cases. And once the votes have been tallied, then the discussion turns to the opinion assignments, and the presiding judge typically sort of monitors that and supervises that. But I found, like, consistent with the collegiality of the court, that we're pretty open about making assignments depending on the needs and interests of a particular judge. Obviously, if a judge is on a different side of the V in terms of affirming or dissenting, then that will dictate where the assignments are headed. But by and large, that collegiality extends to opinion assignments, and we typically get our fair share of cases that we might have an interest in, and some that may not be quite as interesting for us personally, although each case obviously is critically important to the litigants. And so then those assignments are handed out. The chief judge ultimately has the authority over the work, and his job is to make sure that the work is reasonably allocated in a way that's proportionate and fair to the court as a whole. And sometimes there may be a changing of some assignments depending on the workload that occurs throughout the week. But that's typically how the process works.
And then that opinion is circulated to the whole court before filing at the Fourth Circuit. Is that right?
It is. That's not typical in other circuits, certainly not typical in the Ninth Circuit, where we sat, Judge Thacker and I sat some years back. The other thing that was unique about the Ninth Circuit, which I don't think I mentioned, is that they oftentimes will share bench memos. They don't, because of the volume of the work, they have a judge who's assigned, law clerk who's assigned to write the memo, and those memos are shared with the panel as a whole. That's not something that is part of our tradition, but in our court, yes, those opinions, even if they're not going to be published, if they're the result of an argument, will be shared with the entire court for the court's consideration. And that serves several purposes. One, to be sure that there are not other cases that may be lurking out there that might be at cross purposes with the opinion that's being circulated. And 2, to be sure that our cases remain consistent with the precedent of the court, because there may be a judge who has had an opinion in a different case that he or she wants to bring to the attention of the court, or may want to voice his or her disagreement with the rationale of the panel's opinion. And the panel, panel members take those considerations very seriously. We view them very carefully and decide what to do with those views. And I think it's, as I said, part of the collegiality of the court that we engage in that broader process of having our work considered by the entire panel, by the entire court, sorry.
Let's turn to how counsel should address the judges at the Fourth Circuit, especially female judges. Judge Thacker?
Yes, thank you for that question. First of all, just to judges generally on our court, on the Fourth Circuit, I think we may be somewhat unique in that we don't list the names of the panel members until the morning of argument. And I think the reasoning for that is your argument should be geared toward the facts and the law, and who the judges are on the panel generally shouldn't matter. However, I would think since there are only 15 of us, it would be good to just be generally familiar with the names and who the 15 judges are, so that when you do see your panel that morning, you at least are ready to properly pronounce their names, and also to recognize that if there is a key case relevant to your argument and one of the judges on the panel actually wrote that case, it's probably a good thing to recognize that when you're engaging with that judge. And oftentimes that surprisingly doesn't happen. So it's good to address the judges all by, Judge Diaz or Judge Thacker or Your Honor, and to know how to pronounce their names. In terms of the female judges on the court, Judge Diaz and I just spoke about this a couple weeks ago, actually, because ma'am is certainly an honorific in most circumstances. People would imagine that it would be, and it is. But what I and some of my female colleagues on the court have noticed is that often during arguments, the male judges may be referred to as Your Honor or Judge so-and-so, and we're referred to as ma'am. And it's, talk about distracting. It is a little distracting, and we don't prefer it. We prefer to be referred to as Judge or Your Honor as well. And I didn't realize really that it was something that people didn't really think about. I mean, it's just naturally you say ma'am as an honorific, in the same way that you would say sir, except the difference is they're not saying sir, they're saying Your Honor or Judge. Until a couple years ago, one of my good friends and former law partners called me. He had an argument in front of a federal female magistrate judge, and his co-counsel was a woman. And I guess he just referred to the judge throughout as ma'am. And his co-counsel, who was a woman, told him afterwards, you probably shouldn't do that. It'd be preferable if you referred to her as Judge or Your Honor. And he was just shocked by it, so much so that he had to call me and ask me if I cared whether I was called ma'am instead of Judge. And it may sound sort of, I don't know how it may sound, but I said, yes, I do care. You should call me Judge or Your Honor in the same way that you would refer to my colleagues. But, people just don't think about it. So I'm glad to have the opportunity to address it. Something that perhaps you should think about, because it grates me a little bit when I hear it on the bench. Actually, it grates me off the bench because ma'am sounds sort of old. So I don't like that then either.
Judge Thacker, thank you. Judge Diaz, can you just, one of the kind of anxiety-ridden parts of getting ready for oral argument is kind of anticipating what the questions might be that the panel might be posing. Maybe some advice for practitioners who, like me, have that anxiety when I have that oral argument.
Sure, and I get that, and I think what we talked about earlier, the importance of being responsive to the court's concerns, and this is a critical part of that process, right? If we've got the case on the calendar, as I mentioned, it's for a reason, and that is that we are having difficulty with an issue in the case, and we want the lawyer's help. And the best way that a lawyer can be effective and helpful is to be responsive to the court's questions. 20 minutes is not a lot of time, but it can be an eternity if you're not engaged with the court and responsive to the court's concerns. And what ultimately what it comes down to is being prepared, having a sort of a full understanding of the issues and the record and the briefs. And there's no substitute for that kind of preparation. So beforehand, you and your colleagues, if you're doing, and you should be doing moot courts, need to sit down and predict. And oftentimes they're entirely predictable what the questions are going to be. Now, the answers may not be predictable, and that may be the difficult part, but you can certainly sort of sense, whether it be an employment appeal or any other appeal, there are going to be some questions that are going to come your way that you need to be ready to respond to. And part of that process is being able to have sufficient time in advance to prepare so that you can focus on the case for a little while and then maybe get away from it for a bit, because we all get tunnel vision when it comes to certain things. I know I do. You sort of focus, you get in the weeds and you lose the forest for the trees. But if you take the time to prepare and then maybe take a step away and come back to a case, you will see it with different eyes, and you may see things that you hadn't seen before in terms of the issues that might matter to the court. But it all comes down to being prepared, to doing moot courts, having your colleagues moot you and ask you questions. You know, oftentimes when I prepare for oral argument, our process here in chambers is everybody gathers around the table and the law clerks present the cases to the entire chambers. And it's always interesting when you have a law clerk who has not been engaged in a case, they'll ask a question, a foundational question that all of us have just entirely missed because we've gotten so deep into the weeds of a case that we haven't focused on this really fundamental question. And it's that kind of interaction with others who may not be as invested in the case as you that's really helpful in terms of being able to be prepared to respond to questions that you simply might not have thought about because of your sort of laser-like focus on the details and the weeds.
Let's turn to 28J letters. Judge Thacker, some advice for counsel when thinking about filing a 28J letter.
I would say, first of all, make sure it is an appropriate 28J letter, that it complies with the rules. That is, you know, it's a case that has come out after perhaps the briefs were filed, after key points, key time periods in your case, rather than 1975 case from, you know, a Colorado state court. That probably doesn't need to be filed, but it does happen that if, you know, that you're preparing for argument after you filed the briefs, or something's, or a new case has come up after you filed the briefs, you're preparing for oral argument. And, you know, if you do come up with a new case, then do file a 28J letter. It's far better to file a 28J letter, even at the last minute. We had oral arguments in September a few weeks ago, and the morning of, literally, I was in one of the arguments when I was handed a 28J letter in another argument that was coming up, but it was a case that was applicable. So not only should you file it if it's a new case, but you should make sure to give it to opposing counsel and to the court. It's sort of a pet peeve of mine when lawyers argue a new case in front of the court, not just because maybe we haven't seen it, we can find it that when we're working on opinions, that's fine, but more so your opposing counsel hasn't seen it. So that's a problem with civility, and it's something that happened to me when I was arguing before the Fourth Circuit a long time ago, and perhaps that's why it's a pet peeve of mine, because the opposing counsel handed me, literally as he got up to argue, he was the appellant, a case that was really long. And I was already freaked out because the panel was Judge Wilkinson and Judge Motz and a district court judge. I mean, Judge Motz and Judge Wilkinson, you can't get more sort of powerhouse than that. And he hands me this case out of nowhere. And so I'm trying to prepare. I get up there. Of course, Judge Wilkinson's all over me about this case. I mean, all over me about this case. And he had just handed it to me. And then finally, out of nowhere, like a white knight on her steed, Judge Mott said, "It's not her fault, it's his fault. I just saw him hand it to her." So I have a little pet peeve about 28J letters when that happens, or things that are no 28J letters, things that are come up and are argued without opposing counsel. I will often ask, did you give it to opposing counsel? So do file 28J letters when you find them necessary.
Let's
Even
turn to
a minute.
Let's turn to opinion drafting. Judge Thacker, step us through your opinion drafting process.
Oh boy, that's I have quite a long process for opinion drafting. First, during oral argument, I will frequently make notes of good points that one or the other side has made, or just as frequently that one of my colleagues has made, that I want to make sure to include in the opinion should I get the assignment to write it. Then my process is whichever law clerk had the bench memo does the first draft of the opinion. And before drafting that opinion, they can look to a searchable database that we have called the Thacker Opinion Digest, where every particularly published opinion that I've written is in there by subject matter, so we can make sure that we're not at cross purposes with ourselves, and that if I've said something before, I say the same thing, hopefully again, unless I'm wrong for some reason. I'm not above changing my mind. So then once the law clerk who wrote the bench memo and I go back and forth with edits and we get it to where we feel comfortable with it, then I pick another of the term clerks to be the second reviewer. They are that outside person, the person who isn't a party to the case, the person who might be picking up the opinion and reading it and looking at it with fresh eyes, looks for any analytical holes, any questions they might have, sort of like what Judge Diaz said, the person who wasn't involved in the case asks the best questions, maybe when they're preparing for oral argument, just looking for typos, anything that stands out. And then we go back and forth on that second review edit process. And then after that, they all go to my career clerk for final consistency review, which is just what it sounds like. It's a review for consistency across cases and styles and opinions that we've had. And also she looks at everything too, if she has an analytical hole or a typo or a question. So we go back and forth on that. And then it is time for final, I really mean it, final review. And that's when I review it and make my final edits. And then luckily we, as Judge Diaz mentioned, all of our opinions are circulated to the entire court. One of the things I particularly appreciate about being on this court is the concept of several heads are better than one. So not only can my panel members weigh in with their good suggestions and edits, but sometimes people, judges who weren't on the panel have thoughts that are helpful too. So that is how an opinion becomes an opinion in my chambers.
Let's talk about rehearing and rehearing en banc. And Judge Diaz, what's maybe the least understood aspect of when rehearing or rehearing en banc is appropriate? Maybe give us some sense of what works and what doesn't.
Right. So this is not so much a problem for lawyers, although some have a sense that somehow rehearing en banc is a matter of right and happens in, should happen in virtually every case. It's more typical that pro se litigants tend to not have an understanding, or maybe even if they do, choose to ignore their understanding of rehearing en banc, will file rehearing as a matter of course. But obviously that's not what the rule is intended for. It's not simply that the case was wrongly decided, but there must be something else that matters about the case. It's wrongly decided because it's inconsistent with the precedent, or it's something that inconsistent with other circuits' case law, or some other significant issue beyond the merits of the case that warrant that the case be reheard. On our court, it's tradition, although certainly not written down anywhere by regulation or otherwise, that it's not typical for a judge who is outside of the panel to call for a vote on a case to go en banc. It does happen occasionally, but not anywhere near as frequently as it apparently happens in other circuits. And that's, I think, part of our tradition of civility and professionalism, that the panel's work is important. And by and large, a judge, although we all have obligations to look at these, and we do look at the petitions for rehearing carefully, that the panel's work is presumed to be correct and should stand. Now, if there's a dissent in the panel opinion, I think that's an entirely different ball of wax, and that's probably the strongest indicator that there might be a possibility that the case could go en banc if there's a dissent, particularly a vigorous dissent, that might serve as the sort of lead in to have the panel reconsider the opinion or the case to go en banc. I will say this: we on average, maybe we hear one en banc case per sitting, maybe two, or so maybe 8 or 10 per year, more or less. So not a lot of cases go en banc, and I think that's the way it should be, because truth be told, I think the en banc process sometimes leads to more confusion than light. I remember when I was, I think it was the second year I was on the court, Judge Thacker, I think you were on part of this en banc rehearing. It had to do with the dreaded criminal case and the dreaded modified categorical approach, and trying to shed some light on that. And you employment lawyers, if you don't know anything about this, count your blessings, because it's not something that, something that will make your eyes roll if you had to deal with it. But anyway, the case went en banc, and predictably, we had 5 or 6 different opinions, completely fractured court in terms of the analysis. The opinion gets published, it goes out to the world at large, and I get this email from one of our distinguished district court judges with the subject, WTF, ? And that's all he said. And frankly, I had no rebuttal, because he was entirely right. I mean, it just wasn't at all helpful. And so that can be sort of the downside of taking a case en banc. It does serve an important purpose. Obviously, it's there to act as a safety valve to make sure that a panel hasn't gone off into the hinterlands and lost itself. But it should not. It's the exception rather than the rule, and should, in my view, remain as such.
So when you're crafting that petition, how do you do so in identifying, for example, that there was a mistake, or maybe that the decision deepened a circuit split without seeming uncivil?
Well, I don't think it pays to engage, as I said, in histrionics, or say, my pants are on fire, my hair is on fire, you need to fix this, or else, the whole world's going to come crashing down. I mean, you just simply point it out. And, it's not to say that we don't make mistakes. I've been on panels where we have gone back and granted panel rehearing, precisely because a lawyer pointed out a mistake in the panel's analysis. We're not beyond that. I think we're all human. We make mistakes. Now, hopefully it doesn't happen often. Thankfully, it does not. But when it does, we're not above revisiting a case. And certainly my colleagues are not above challenging the analysis of a panel if, in fact, they think strongly that not only was it wrong, but it was so wrong that it's sort of entirely inconsistent with prior precedent. It puts us at odds with the majority of circuits across the country, and some other good reason why a case needs to be reheard. And a good, effective lawyer can bring that out without sounding uncivil and without making it personal.
So Judge Diaz, I know you were a trial lawyer yourself, and then of course a trial judge. And I want to get a sense of your view on the Seventh Amendment right to a jury trial. Having, tried cases and sat as a trial judge, what's your view?
Well, I know a lot of people have bemoaned the loss of the vanishing jury trial, and I think that's a reality. Cases that are tried are few and far between. In some respects, that may be a good thing in the sense that cases get settled and people can go about their business. But on the other hand, I think there's something lost there when we don't have members of the community engaged in what is in essence their justice system. I came from a tradition in the military where we had so-called blue ribbon panels. They were panels that were selected by the commander who convened a court-martial. This is in criminal cases. And they were almost uniformly very well educated, either officers or senior staff non-commissioned officers. And when I left the military and went into private practice and state court practice in particular, I was really concerned about how that cross-section of the community jury system would compare to what I was used to. And I will say that and when I became a trial judge, this became particularly pronounced. I will say that I have grown to have a very healthy respect for our jury system. I think jurors, it's probably the last thing that they want to do when they come to a courtroom to serve on a jury, but once they get there and once they understand and appreciate the gravity of the moment, they do by and large their level best to try to get it right. And they pay careful attention both to the evidence and the lawyer's presentations and the court's instructions. And I was really taken by that as a trial judge. And Judge Thacker, I know, has sat as a district court judge and probably has some thoughts about this too. It's really encouraging to see. There's a lot about our current day institutions that seem to be failing us, but I don't, there's a lot of folks who are at cross purposes with each other in our larger society, but I think the jury system remains as one of those shining lights that often works and works well.
Judge Thacker, give us a sense of maybe what surprised you the most when you came to the Fourth Circuit, maybe that you didn't fully expect.
I think what I didn't fully expect to come full circle to what we're talking about, or didn't fully appreciate, is really the level of collegiality among the judges on our court. You see it in one respect on the other side of the bench, that is, coming down to shake hands, but it's really in full view. And I was surprised by it, as I think maybe people outside the court might be when, you read our opinions and sometimes you disagree. You think that perhaps you could think we actually don't like each other, when in reality we do. We keep up with each other's families. We, go to lunches and dinners and everything together. And we work very hard to respect and appreciate each other, even when we disagree. And I have, just without attribution, a couple letters I wanted to read of the sorts of things that we say to each other to foster that level of civility in the court, even when we disagree. And this is amongst all facets of judges. The first one says, "I have no changes to my dissenting opinion. While we see the case differently, I appreciate your well-written and thoughtful opinion. And I hope you and all our colleagues had an enjoyable Memorial Day weekend." The next one says, again with a dissent, "Take whatever time you need to revise your dissent to the court's decision. I look forward to your response. My summer is going quite well, and I hope the same for you." The last one is, "You have done your usual thorough and insightful job on this opinion. Although we disagree, it is a pleasure to sit with you." And that's how it is on our court every day. I could pick out a handful of these letters just from today, or even keeping up with each other, with new grandkids and new puppies and things like that. So that's what surprised me the most about being on this court, and I couldn't do it otherwise, actually.
Judge Diaz, what's your advice to experienced lawyers that are with us today about teaching newer lawyers the importance of civility and professionalism?
It's critically important that those who have been around for a bit and understand how important it is that our system models civility and professionalism, that they, inculcate those lessons to those who come behind them. And I think the best way to do that is is simply by doing, day in and day out, serving as an example of what it means to be a professional in all that you do. Because young associates, young lawyers, young law clerks, they watch their mentors, both the good things and the not so good things that they model. And they look to those mentors for lessons learned. And so, we can talk about this till the cows come home, but it's in the day-to-day practice, the day-to-day civility and courtesies that lawyers display towards each other and judges display toward lawyers, that we model civility for those who are going to come behind us. This is and remains a profession. And of course, the pressures of business and business development sometimes are important, because obviously we all want to be able to, as lawyers in particular, want to make a living and do the things that we need to do to take care of our family and our colleagues. But in the end, we've been granted this license, which is a privilege that is not easily granted to many. And we have a responsibility. And part of that responsibility is to be sure that those who come behind us understand the importance of the work that they do, the impact that they have on lives and in our society, the outsized impact, frankly, that they have on those who rely on them for counsel and advice and representation. And the most effective way to move that ball forward is for those who are in a position of leadership to model and serve as an example for those who come behind them.
Before we turn to final thoughts, Judge Thacker, the courthouse in Richmond has a number of different courtrooms for oral argument. Do you have any preferences?
I do. So we call the courtrooms by the color of their carpet. So tweed, green, red, blue. My favorite is the red courtroom, first of all, because well, they're all beautiful, but I think it's the most beautiful and historic, and it has windows in there that let sunlight in, which I appreciate. But for me personally, that courtroom is my favorite currently, because in that courtroom, the last 3 circuit judges to have passed are behind the bench, their portraits. And so the circuit judge who I succeeded in West Virginia on the 4th Circuit, Judge Blaine Michael, sits right, his portrait is right over my shoulder in that courtroom. And then the other judge that was in my seat before Judge Michael, Judge James Sprouse, his portrait is directly in front of me. So when I sit there, I can feel sort of the full weight of the seat that I hold on this court. And I always look at Judge Sprouse and Judge Michael and hope that I'm a worthy successor to both of them. In fact, Judge Michael's portrait, you probably can't see it, but it's behind me right now. And I look to that frequently, part of the history of the 4th Circuit.
Thank you. We're ready for final thoughts. Judge Diaz.
I just want to thank you, Scott, and the association and the college for allowing us to be a part of this important discussion. I trust that it was fruitful and helpful. And I will leave with So thanks to my colleague, Judge Thacker. And Judge Thacker, Emma says hello. Pass along my hello to Huey and Bernie, Judge Thacker's two canine friends who I've gotten to know over the years. We have formed a friendship via online with photos and videos and the like. And it's been a lot of fun. So thank you, Scott.
Oh, you're most welcome. Thank you. Judge Thacker.
Yes, I echo Judge Diaz's thoughts. I appreciate the opportunity to be here today and speak with you all on this important topic. I'll close with what was the extra credit question on my ethics exam in law school. My professor frequently talked about this, and the extra credit question was a quote from Oliver Wendell Holmes. And what was it? And it was, "It is possible to live greatly in the law." And I trust that each of you all do that every day.
Our thanks to Judge Stephanie Thacker and to Judge Albert Diaz for participating today, for all of you for being here. For more information about the College of Labor and Employment Lawyers, you can find us at www.laborandemploymentcollege.org. For future programming from the Metropolitan Washington Employment Lawyers Association, you can find us at www.MWELA.org. Really appreciate you being here today. Look forward to seeing you next time.